Wow, what a crowd. I think, that, as the late Dean Martin used to say, who are these people doing in my bedroom? It's nice to have everybody back together again. See great Bill Wichterman, Mike is here from Texas, and Doug Meyer, and so good to see everybody. This is a time for gratitude and celebration, but also time for reflection and serious worries. It's time for Midge Decter's Jewish telegram. Start worrying now, details to follow. And I don't want to sound like that character, that very old story about the man who gets fed up in the advertising business in New York, and he checks himself into a monastery in upstate New York with the rule that you get to speak 2 words every 5 years. After serving 5 years, he's brought to the office of the abbot and he says, hard beds. Another 5 years, he comes in and says, bad food. 5 more years go by and he comes by and he says, miss television. Another 5 years, he comes and says, going home. And the abbot says, I shouldn't be surprised. You've been a constant complainer since you've been here. Well, it's a time of celebration, but I do have some complaints. I began writing in the pro-life cause in 1972, before Roe versus Wade. And I take a moment to lament those friends who were working on this even earlier than I did and didn't live to see this day. We think of the blessed Mike Heuvelman, Bernie Nathanson, John Noonan, Mildred Jefferson, Joe Stat, and yes, Nino Scalia. But that gives us even more reason to ask just whether that overruling in Dobbs really declared and pronounced that the wrong we had worked so hard to undo, and has that decision really laid the groundwork for our jurisprudence going forward. A good friend of mine in neurosciences told me long ago, if you hold a light to the retina, it yields a vast amount of information about the state of the organism. Dobbs was the light held to the retina, and reveals some differences really running deep within the conservative family. I wanted to call this talk sort of after Dobbs, looking back and looking ahead. I'd like to look ahead by drawing upon some of those things we've learned over the last 49 years. I want to take you back about 35 years when our friend Rich Derflinger of the Bishops' Conference studied the surveys on abortion, and he came to the judgment that 60% of the public were opposed to 90% of the abortions being performed under Roe versus Wade and the companion case of Doe versus Bolton. But the same survey showed people massively opposed to overturning Roe. Well, how do you account for that? We thought it was obvious. Most people don't know what's in Roe. Marianne Glendon, our friend at the Harvard Law School, took a survey among 25 of her colleagues. Only 5 could give a faintly accurate account of what was in Roe. And at my own dinner table years ago, our beloved Gene Rostow, Gene was a Sterling professor at Yale, almost just gagged in disbelief when I told you can have an abortion through the entire length of the pregnancy, and even after the child comes out. We had that case in Tennessee in Floyd versus Anders, 1977, of a child who survived the abortion, went to surgery, died. And the question was raised, was there an obligation to preserve the life of this child? And the answer tendered by Judge Hainsworth was, no, that is not a child protected by state law. It's a fetus marked for termination. And that's what moves some of us to come forward with that most modest of all first step in legislating on abortion, the bill to protect the child who survives the abortion, the so-called Born Alive Infants Protection Act. And it was what motivated some of us to come back in 2015 for a new iteration of that bill for the sake of restoring the serious penalties, civil and criminal, that had been stripped from that bill for the sake of averting a veto from Bill Clinton. For we'd come to discover that there was far more killing in much larger numbers than we had ever suspected at the time. And then we had the dramatic evidence of Dr. Kermit Gosnell in Philadelphia with his filthy clinic, routinely killing babies who'd survived the abortions. The rationale for that first bill, to protect the child born alive, was that it would break out news that the public would find jolting, that one could have an abortion throughout the pregnancy and kill the child later. Now, 49 years later, the news still hasn't broken out. The American public still does not know that you can have an abortion so late, nor does it know that the overruling of Roe would not mean the outlawing of abortion in the whole country, but simply the return of that issue to the separate states, with abortions still being performed in large numbers in the blue states. And so again, how could it be, with the vast powers of research and broadcasting contained in the major media, that the American people have been kept in this state of innocence so long, with this news withheld from them? Well, how could we have foreseen this? I mean, I had only a doctorate in political science. I mean, how could I imagine that the media, major media, could actually black out this story? And indeed, as even Fox blacks it out today. And they say nothing of the fact that we had those votes in the House on that bill to strengthen the Born Alive Act, both in 2015 and 2018, and that those votes revealed a dramatic transformation in the Democratic Party. Because 20 years ago, when we did the Born Alive Act, passed in 2002, the Democrats, with my nemesis, Jerry Nadler, were furious about it. But for the sake of avoiding embarrassment, they were willing to vote for this measure on a voice vote without taking a roll call. And by the way, this is when the Democrats still had control of the Senate. Harry Reid was what brought it to the floor. But now we found the Democratic Party utterly transformed. We had 2 votes in September 2015, January 2018. Every Republican in the chamber voted for the bill. Virtually every Democrat, except for 5 or 6 surviving pro-life Democrats, voted against it. And so we have a party now committed to the notion that the right to kill that unwanted child does not stop at birth. And that could give us a chilling warning as to how the levers of federal power would be used if the full control of the Congress and the White House came into the hands of this energized progressive party, really determined to sweep away any lingering restrictions on abortion in federal law. For nothing in the Dobbs case really would bar the use of those federal powers. It's only a question of who will use them. That bill to protect the life of the child who survives the abortion curiously has a kind of relevance today, because it may be, again, the critical first step we could take in legislating in Congress. And it could be the most disarming measure we might use in the blue states to see whether people in the blue states are really waiting to take the line of the Democratic Party and have no limits at all on abortion. But when we brought forth that bill, our allies in the pro-life organizations thought it was just too modest. They preferred to put forth a bill on the grisly partial birth abortion, with the head of the child crushed, brain sucked out, the child removed, so to speak, intact. But those bills in the state and Congress were knocked down by the court in June 2000. I was in the chamber that day. In the Seventh Circuit, our friend Dick Posner wrote in striking down the bill on partial birth abortion in Wisconsin, and Posner tweeted us. He said, well, you people never made the claim to protect that fetus in the womb. Why does the state have any compelling interest in shifting the killing of the child from the birth canal back to the uterus? Yeah, and he had a point, which is why he said, at this moment, we have to draw on that old line of Andrew Jackson at the Battle of New Orleans, when he was supposedly said, boys, I want you to elevate them guns a little lower. Let's use the Born Alive Act to put this anchoring premise in place, that even that child marked for an abortion has a claim to the protection of the law. But of course, we never concealed that, of course, we'd coming back right away to ask, what was the difference in that same child 5 minutes earlier, 5 days, 5 weeks? We never concealed that. We thought, okay, look, we'll try to persuade you step by step. If we don't, then from that vast volume of 1.2 million abortions, we'll save a handful of lives, and that we didn't consider any trifling concern, okay? I was given the privilege of leading the testimony for that bill in the House Judiciary Committee, and on that day, our pro-life allies were absolutely flabbergasted when the National Organization of Women and other pro-abortion groups came out in opposition to this bill to protect the child born alive. Their friends couldn't imagine they'd do that. The chilling revelation coming through was that our adversaries understood this better than our own allies because they saw the principle that lay at the heart of the thing. They knew we could unravel their whole position. They were not willing to concede even that first step, as they are not willing to concede it even now. The point, again, that we're trying to make was the point that the lawyers from Texas in Roe sought so compellingly to make, that the law had a justification for reaching and protecting that child in the womb. 49 years ago, those lawyers from Roe assembled the most exquisite brief, drawing on the most updated findings in embryology, woven with principled reasoning for the sake of extracting these points for the court, that offspring in the womb has never been anything other than human from its first moments. It receives its nourishment from its mother, but it has never at any time been really a part of the body of the mother. The dissenters in Roe, Rehnquist and Reingt, did not draw on anything from that brief. And the jarring point for us now is that neither did the 6 conservative judges in the Dobbs case. Indeed, following the rule book of conservative jurisprudence, the conservative majority deliberately steered around that cardinal point about the human standing of the child in the womb. And that holding back makes a profound difference for our law and for our politics right now. For if they had put that point in place, they had reasons for not doing it. If they had put that point in place, they have returned matters to the states with the understanding that we're dealing here with the taking of human lives, and we're inviting the states to judge how the taking of these small lives will be reconciled with their usual laws on homicide. The laws on homicide have ever been indifferent to the size and age of the victim. The killing of an old or heavy man is not a worse homicide than the killing of the smallest child. But the court did not put that key point in place, and it's clear now that the omission was not a matter of oversight or accident. If the court had put that simple point in place on the human standing of the child, the premises would be established now for federal judges in the Congress to intervene under the 14th Amendment when the protections of the law are being withdrawn from a whole class of human beings in the blue states, much in the way that the courts and the Congress worked through the coils of federalism in the 50s and 60s. You might remember the Screws case and things like that, working through the coils of federalism before they could understand that they had a ground to act directly when the protections of the law were being withdrawn from black people in the South. What we're seeing at work in the Dobbs case is the work of a jurisprudence firmed up over 45 years, taking it as a matter of high discipline that conservative jurisprudence must steer away from touching the moral substance of the case before us. That it was wholly needless can be seen in the paths that were foregone at the very beginning in Roe versus Wade. For at that moment, the court could have made the kind of judgment that courts and judges routinely make. I mean, judges are called on at every turn to judge whether the state is justified in searching the driveway of a private home for looking for stolen vehicles, or whether the law is justified or unjustified in ordering the search of body cavities, looking for illegal drugs. There's nothing unusual about this. The justices in Roe could have said, as they said in many other cases, that they've reviewed the impressive data and the reasoning, and they're compelled to conclude that the laws in Texas were amply justified, in this case justified, in casting their protections over those small human beings residing for well in their mother's wombs. But instead of making that familiar move, the majority and the dissenters in Roe drew nothing from that rich body of material. The dissenters in Roe retreated to a theory from that rich body of material. They retreated to a theory about the guidelines confining judges. It was a theory that the common man would not readily understand and may not understand even now. What we'd hear day in and day out was that the right to abortion was nowhere mentioned in the text of the Constitution. Therefore, federal judges were not in a position to declare any rights to abortion springing from that Constitution. Okay. But as Gerard Bradley pointed out long ago, the Congress had ample reason to make abortion the business of the federal government say in military hospitals, in military and diplomatic outposts abroad, in the territories, the District of Columbia, and the Congress did indeed bar abortion in those federal enclaves. There was nothing in the Constitution about marriage in 1967 when the court struck down those laws barring interracial marriage. And none of my friends, none of the conservatives, have been asking, where is marriage in the Constitution? How did you get to that? But we heard again from Justice Kavanaugh that abortion was nowhere mentioned in the text of the Constitution. In fact, the Constitution, he said, was neutral on abortion. And so people in the separate states should be free to vote abortion up and down. It apparently slipped the notice of Justice Kavanaugh was that he was offering a chilling echo of the famous encounter between Abraham Lincoln and Stephen Douglas in their debates in 1858. It was Douglas' position that the country could avoid that vexing, divisive issue of slavery simply by leaving it to the settlers in the territories to vote slavery up or down as it suited their interests. He said, look, in Maine we have laws on oysters, in Indiana we have cranberries, and some places use slave labor. Well, Lincoln thought this was just the degradation. These are morally indifferent things. This was the degradation of the democratic dogma to say that the regime was all process and no substance. You could do virtually anything you want. The policies of genocide, slavery, as long as they were done with all the trappings of legality, with a voter majority. But we can ask the question, is the American Constitution, is the American regime truly neutral on the matter, say, of genocide or slavery? Does a regime of law not begin by taking seriously the difference between innocence and guilt? That we visit punishment on people only as we show that they're guilty of the kind of wrongdoing that deserves punishment? And the natural right to life never meant a right to life everlasting. It meant the right of an ordinary person, innocent of wrongdoing, to be protected from a lawless, unjustified assault on his life. So how could anyone understand those moral premises underlying this regime and think that there was nothing in those deep principles that could possibly be neutral or indifferent on the question of whether the Constitution would license a regime of killing small, innocent human beings? Justice White, dissenting in Roe, deplored the possibility of taking small human lives, they could be ordered up for the sake of convenience. But then he quickly shifted the focus and transformed the question. The victim was no longer the child being dismembered, but the people and voters in the separate states who were now being deprived of their freedom to deliberate with one another on just who was covered in their laws on homicide. And so the corrective, trumpeted on the conservative side, was to send matters back into the political arena and the states. The question put aside then was, what was the nature of that living being who was at the center of the problem? Over the years, the courts have altered our understanding of what counts as the human person who is the subject of the laws and the bearer of rights. As Lincoln put it in his own day, in the crisis of his own time, the question is that black man, is that black man not, or is he a human being? If he's not a human being, then anyone who is has a right to do with him what he pleases. But if he is a human being, then he too has the right to govern himself. And Henry Jaffa would later say, the question of whether the black man is a human being cannot be a value judgment. Value judgment is a term that came into play with Nietzsche and Max Weber when people lost their confidence in speaking about moral truths. We impute moral worth to things as we value them. So would the human standing of the black man depend then on whether people in the states cared enough to value him as a member of their race and as a potential fellow citizen? But then we skip ahead to Planned Parenthood versus Casey in 1992, and here one of my dearest friends, writing for dissent, said, the whole argument of abortion is whether that offspring in the womb is a human life. He said, there is no legal answer to that question. It must be a value judgment. Now, I submit to you that if it makes no sense to submit the human standing of the black man to the value judgments of people in the separate states, it makes as little sense to invite people to offer their, quote, value judgments on when they think human life begins. What might people say, when the child in the womb begins to squint and swallow at the age of 9 or 10 weeks, when the fetal heartbeat can be picked up with Doppler devices at 6 weeks. But none of these things, marks the beginning of a human life. They're simply stages in the development of the same human being, powering it, integrating its own growth from one stage to another. The conservative majority, as it stands in Dobbs, would send the issue back to the states, thanks to Justice Kavanaugh, on the premise that there is no truth to be known on this matter. Now, that this was indeed where the issue was left was confirmed quite tellingly in the concurring of Justice Kavanaugh, where he noted that many pro-life advocates forcefully argue that the fetus is a human life, as though there's not been any long-settled empirical truth on this matter found in all the textbooks on embryology. In other words, in this mode of conservative jurisprudence, the judges must affect not to know the plainest objective truth that bears on the practical judgment before them. Which is to say, in this vein, conservative jurisprudence takes its beginning on this matter by its willingness to live affably with a radical falsehood. And that concurrence by Kavanaugh is the telling sign that the opinion in Dobbs left the human standing of the child to the value judgments reached by people in the states. And so the child in the womb is still referred to, as Jerry Dick points out, merely a potential human being. A term makes no sense at all, as Sam surely knows. If there's something alive and growing there, an abortion would no more be if there's nothing growing and alive there, an abortion would be no more indicated than a tonsillectomy. If it is growing, we know what it is. It could be, maybe a potential outfielder or potential plumber. It's never been anything but a potential human being. As the strands come together, the bleakness of the situation becomes ever clearer in this respect. That for conservative jurisprudence right now, as they have it, the life of the child in the womb does not supply the ground of the constitutional argument or the object of official concern. Regrettably, it was the dissenters in Dobbs that nailed this point. They said that the majority takes pride in not expressing a view about the status of the fetus, that the state interest in protecting fetal life plays no part in the majority's analysis. The center of the problem for the conservative judges here was a theory about the rightful and wrongful reach of the judges, quite apart from the moral substance of the case. The depth of the problem is revealed here when we consider the long historical record that Justice Alito unfolded, showing how far back the common law casts its protection on the child in the womb. But that historical reading was given radically different meanings by the dissenters, as well as the members of the conservative majority. For the conservative majority, the historical record fitted the conservative argument over substantive due process. The judges may act to create dramatic new rights under the Due Process Clause only when there's a record of a right long recognized in our tradition. What the historical record established for the conservatives was summed up by Justice Alito, that we're aware of no common law case or authority that suggests a positive right to procure an abortion at any stage of pregnancy. And so it was wrong for the Supreme Court to snatch that matter from the states. For the defenders of abortion and the dissenters in Dobbs, for them, the historical record revealed something notably different. It revealed what people in the 18th and 19th century believed about abortion. For the defenders of abortion, this is simply one set of beliefs against others. For after all, the conservative majority never said that the record revealed a firming understanding in the medical profession about the objective truth of life growing in the womb. For the defenders of abortion, those laws of the 19th century were passed before it was understood how important abortion was to women. The historical record for them was simply a record of what men were willing to impose on women before women had the vote. The key to the problem here is really a variant of the old problem of Plato's Euthyphro. Is the old good because it is old, or has it become old because there's something about it enduringly good? Were those earlier laws to be respected were they old because they revealed an objective truth about the child in the womb that is as fully true now as it was then? Justice Kavanaugh's concurring opinion is the telling point of confirmation that this understanding of the historical record, that it revealed the human standing of the child, was not the understanding adopted by the conservative majority. There's no way in which Kavanaugh could have written that concurrence and said people nowadays simply had different beliefs about life in the womb if the majority had really set down that the historical record had unfolded a deepening objective truth about the life in the womb. And this may be the price that Sam Alito had to pay in order to get 5 votes to overrule Roe versus Wade. The alternative to this path was suggested at a moment 36 years ago, 1986. People seem to have forgotten about this moment. In the Thornburg case from Pennsylvania, when Byron White, one of the original dissenters in Roe, startled Justice Stevens by saying, well, I too could accept a constitutional right to abortion. If we're put on the same plane as all those other precedents that led to the right to marry never meant you could restrict marriage for many reasons at many points. So his position was, well, I too could accept the constitutional right to abortion if it were put on the level where most people in the country, pro-lifers and pro-choicers, would understand and accept it, namely, where the life of the mother is endangered. And then he said we could leave everything else to the public to decide with their legislators. But Stevens thought this was a ruse. He found it astonishing that White would say that he accepts abortion when the life of the mother was in danger, yet he insists at the same time that the governmental interest in protecting fetal life is equally compelling to the entire period from the moment of conception until the moment of birth. To Stevens, it was unfathomable as to White how he could say that a decision not to bear a child that is made a few days after conception is less fundamental than a comparable decision made before conception. The only difference was, after all, was there something growing there in the womb. For the critical point, as Stevens said, was that White refused to embrace that critical point, well recognized, that the recognized difference between a fetus and a human being. Now, ladies and gentlemen, the measure of our current situation is that, thanks to Kavanaugh's concurring opinion, that witless rendition by Justice Stevens remains an arguable and legitimate opinion in our law, for the majority did nothing to put it away. And so do we have here. The court in Roe had not merely created a right to abortion, it changed the culture. It changed abortion from a thing abhorred, condemned, discouraged, forbidden, into a thing to be approved, celebrated, and promoted. It should surprise no one that with the overturning of Roe, many people were seized with the feeling that they were being deprived overnight of a powerful, deep good, a right they had come to consider an anchor of their personal freedom, far more than the freedom of religion and the press. And what has been the comparable response to offset or counter that sense of profound injustice? Well, nothing exactly, because the conservatives were willing to follow the path of Justice Holmes. Holmes said it would be a decided gain if every word of moral significance could be banished from the law altogether. For the past 40 to 50 years, my people have been packing into the understanding that the law would not be results-oriented. A law made ever pure as law as it sought some neutral principles cleansed of those moral judgments that must ever divide people. So now again we have the crisis of the house divided. And as in the past, it's a highly unstable balance with a dynamic likely to move to one side or the other. One side is filled with moral outrage, animated by moral energy, fiercely convinced that something of deep moral significance has been taken from them. To their side have come the major media, major law firms, sending out now teams of young lawyers acting pro bono to bring down those laws on abortion in the pro-life states. And on the other side, the conservatives take pride, as the dissent said, in offering no moral teaching here. And so Justice Kavanaugh made clear we deliberately held back from announcing on the wrong of abortion. We'll treat that simply as a matter to be left to the value judgment of the states, including the value judgment whether that thing in the womb is human. The conservatives have sought for 50 years to kill the great white whale of Roe, but they might have killed the wrong whale. They disposed of Roe as a formal legal matter while doing nothing to adjust the force of Roe in its deep moral teaching about the profound rightness of abortion. In contrast, it was the Supreme Court in the 1950s and 60s that laid the groundwork and prepared public opinion to make far more possible the Civil Rights Act of 1964. The court, in the old style of Republican schoolmaster, offered tutoring step by step on the wrongness of racial discrimination, so it kind of prepared the path for Congress to take. That is what the court in Dobbs has so far failed to do, and yet, thanks to Justice Alito, the path has been prepared for the court to start offering that moral prodding. One of the most notable accomplishments of Sam Alito's opinion is that he showed that there's no principled ground for the array of arguments offered so facilely to show that the fetus is not a human life. He said, yes, after viability, there's a higher chance to sustain the life of the child from the mother, but also, it's the same, Sam would say, it's the same entity. We're talking about the same human being before viability as before. And when do we ever think that a human being ceases to be human when he cannot live on his own and when he suddenly becomes weak and ill and needing the care of others? And as Dan Robinson used to remind us, whales and snail darters and sandhill cranes, along with many other endangered animals, can be protected by federal law, even though no one claims that they're persons. Justice Alito did not draw the conclusion that springs from his penetrating argument. He's brought us to the threshold, and he leaves now to the people in political or judicial office to draw the conclusions and take the next steps. Alito himself could take the next step. The court might be called on to sustain those laws in Texas on the heartbeat bill in 6 weeks. He might take the moment to say now, emphatically, that there surely cannot be any ground any longer, either in science or moral reasoning, to deny the human standing of that child in the womb. Or, and this is Bill Griesbeck and I are thinking along the same lines, a guardian ad litem could come forth in the clinic in the blue states and offer to protect the child. And one of our own conservative judges might find the ground now to recognize that the protection of the laws in the blue states are being withdrawn from a whole class of human beings there. Now, has Alito possibly laid the ground for the High Court coming behind him to sustain that judgment? Well, that is a glimpse of hope. But with sobriety, it may be discounted by the fact that so many judges have come to think that this is a step in moral judgment that somehow judges are somehow barred from taking to pronounce on the rightfulness of protecting small human lives in wombs. And as for the political class, we find friends like John Yoo in Berkeley channeling our late friends Antonin Scalia and Robert Bork, registering their deep doubt that the Constitution protects lives that are prenatal. As Jerry says, there's nothing in the Constitution about it. The Constitution does segment human lives into prenatal and postnatal. Nothing in the Constitution about that. Now, some conservatives argue, well, the common law is not part of the Constitution, as though the moral reasoning of the Constitution was never, that reasoning was never available. Blackstone and James Wilson both argue that human life, the common law protects human life from the first stirrings in the womb, from the moment we know it's there. When the question was, when do we acquire our natural rights? As soon as we come to be. In my own sober looking ahead, my guess is, and Mike will compare my notes here, 25 years from now, abortions will still be performed in high numbers in California and New York. And the voices of conservative jurisprudence will say, well, so be it. We did our part. We put abortion back in the hands of the peoples of the states, and so we live with the result. But in that way, forgetting what the central question had been about the child in the womb. The 6 conservative judges held back from drawing any conclusions of moral significance and handed the matter back over to the conservative political class. But that political class now seems blindsided, not quite able to find its footing, so their sense of how to move in making the argument. Our friend Don McGann, just a couple of nights ago, pointed out to me that the ending of Roe versus Wade has been part of the Republican platform for 40 years. And he said, wouldn't you think in this time, Republicans would have figured out some way to talk about it when it really happens? When we put these ingredients together, they stir an uneasy feeling in some of us that we've seen this movie already. We've been through this before. More precisely, it calls to the mind that moment of high hope and grave disappointment when the court in the Webster case of Missouri in 1989 seemed to be taking the first steps away from Roe and returning the matter to the political arena in the states. And some of us were hugging. I remember Jack Wilkie hugging me that day. But that move triggered a certain crisis and a panic among Republican politicians in the land, men who had claimed to be pro-life when they'd been safely removed from the authority to pass any judgment on the matter. But now the voters in New Jersey and other places were aflame with indignation over possibly being denied a right they'd come to consider central to their lives. And so we found Republican politicians and congressmen like Jim Carter, New Jersey, doing 100-degree turns and becoming overnight passionately pro-choice. What we obviously needed was the leader of the Republican pro-life party, President George H.W. Bush, to come forward to say a word, to dissolve the panic, frame the issue, and give people something moderate and reassuring they could focus on now. Anticipating this moment, I had tried my hand in drafting a statement that Mr. Bush could use in steadying the matter, removing the panic, and marking some of the first gentle steps to take. The lesson, I have to admit, was drawn from our late friend, the great Peter Braestrup. Peter, who in his mid-30s was the head of the New York Times bureau in Saigon during the War in Vietnam. He's a classmate of Bill Buckley's at Yale, class of 51. And Bill said that if Bill ever got power, the first order of business would be hanging Peter Braestrup. And Bill passed on the line, tell Peter that fortunately the Supreme Court would probably bar me from carrying out that precocious fantasy. The lesson came from Peter's great book, Big Story. The story of how the major media were surprised by the Tet Offensive in 1968. They played it as a surprise and a defeat for the United States instead of what it really was, an encounter that decimated the Vietnamese army. President Johnson, LBJ, knew that this was coming, and he did nothing to prepare the country for the shock when it came. And the reporters then were set loose and inventing their own storylines. The striking contrast, said Braestrup, came with the May Offensive in 1972, when President Nixon got on the air to tell people this was coming, and this is how we're going to deal with it. He gave to the press their storyline. Reporters were not scampering around to make up a story of their own, and there was no panic in the land. With that sense in mind, I had sent along a draft through the channels, and I would have had the president say, look, we've been ruled on this matter so long by the courts that we need a conversation before we can legislate again. The other side insists that abortion is not infanticide. They imply they're willing to protect the child at some point. So let's invite them to tell us where they're willing to start protecting it. If nothing else comes forth, we say, well, how about when the child's born? Could we at least agree on that? That could have been enough, I think, to get the Jim Carters of the world through the day without panicking, giving them something reassuring to hold on to. And the same thing might be said today in offering the Born Alive Act as a modest beginning, still to be done. We get out of line now to relieve at once those bizarre fears that are being fanned now, that when the laws may restrict abortions, women will lose their right to abortion even when their own lives are in danger. You know, the word should be put out widely that this is one point at which virtually all pro-lifers will agree with the proponents of abortion. No one will be denied the right of woman to make her own choice, weigh her own risks when her life could be in danger. And once that assurance is put in place, it remains for people in different communities to decide just how early, and how much will be done to protect that child in the womb, that child. And that speech, I think, could still be made by someone in some signal position. At this moment of high tension, I sense again the absence of that political man or woman who can frame the issue in public and show us how we can talk about this matter, because surely it's not beyond the understanding of our people. A memoir of my own experience with the Born Alive Act was contained in that book I did called Natural Rights and the Right to Choose. And if you'll forgive me, I'd end this talk by saying the same words I was moved to say then as a culmination of the experience. I said that a political class that has lost the sense that arguments and reason matter is a political class that may serve in positions as officers of state, and yet its members will have lost their vocation. For times the need to clarify the principles entails the need to stage the confrontation, or perhaps even to pick a fight, as we were trying to do back in the Born Alive Act. A political class that's persistently reluctant to show that spirited nature will produce not merely a politics that is banal, but one that's denatured. For removing the conflict, or removing the argument, we may as gently remove the moral substance. Now, Aristotle remarked in that wonderful passage in the Physics that if the art were in the material, we'd see ships growing out of trees. No, but ships are not part of the things produced by the laws of nature, like falling rocks. Ships were part of a world governed by design, by the awareness of ends and the shaping of reasons. So we may be bringing forth a political class more and more detached from the sense that there's any particular importance in compelling the other side to come out with their reasons and claim them as their own. Admit that you for the taking life of the child even after birth. To a political class molding itself in that way, we may not only ask, well, where is the reason that gives meaning to political life, but where in all that is the art? Where do we find a distinctive hand that shows your work? Where do we find the design that marked your understanding, the touch that reflected the experience you have cultivated? And where, finally, do we find the impression, lingering through time, that you were here? Thanks.
Well, thanks, Gerard, and thank you, Hadley, and all of you. I confess it's not an enviable task, and never is, to follow Hadley Arkes to the microphone. Unfavorable comparisons are nearly inevitable. Not only is there the erudition, the insight, but especially the humor. Garrett mentioned, I think, that Hadley's written 10 books, and he named several of them. And then there's the one coming out for Regnery next spring. I think it's Merely Natural Law. But the 12th book is the one that Hadley's been working on all of his life. I fear it'll have to be published posthumously because he's always adding to it. But its tentative title, at least, is The Great American Joke Book. Now, Hadley's a funny guy, but I have to say, anybody can be funny, not anybody, but most people can be funny if they have enough time to prepare and they rummage around for a good story. So yes, Hadley opened up with a few of his favorite jokes, and you can script your first few lines, and I've heard even a couple of them before, the Midge Decter line, the two laconic monks, you know, these are standards in Hadley's joke book. But I can testify under oath that Hadley can be very, very funny on the fly. He's pretty good at ad-libbing, and I'll give you the example that comes most readily to mind. It goes back a long way, I think to 1990, to the first academic conference I ever organized, and it was in Champaign, Illinois. I was teaching at Illinois, and it was on life issues. Hadley was one of the featured speakers, And it's the first time I ever met him, first time I'd ever heard Hadley speak in person. But by the time he got up, he had already met the other conferees and met my family. And when Hadley was getting ready to talk, or when we knew Hadley's turn was coming up, my wife Pam decided she wanted to come hear it as well. But by then we had in those days we always had a babe in arms. We have 8 kids, grown now. But our 4th child was then a year old, Laura Bradley, now I think 33. So Pam had to come with Laura Bradley. And I was there. So Hadley's holding forth in his usual fashion. And another speaker, a mutual friend of ours and someone known to at least some of you, volunteered to hold my daughter Laura in the back of the room. So while Hadley's speaking, I'm sitting with Pam, and Robbie George is walking back and forth in the back of the room holding Laura Bradley. And Hadley was, I don't know if it was a crescendo or one of the downbeats in his talk, but the baby started crying out. Hadley, without missing a beat and without visible distress, just stopped and turned and said, the sound of a baby crying. No matter what the problems of the world are, this is a reassurance that new life, that God is taking care of us. It's just a providential gift. And he said, moved to say, Laura Bradley, Pam and Jerry's 4th, they're young. They're obviously growing a big family. But I feel I should say this to them and to all of you, Jerry and Pam, parents of 4. So Hadley then delivered the following advice. Yeah. Hadley says to the group, especially to me and to my wife, he says, of course, you need to know that every 5th child born in the world is a Chinese communist. I rejoice to say that all 8 of the Bradley kids are Republicans. So my job is mainly, I'm also very much mindful of the fact that the thing standing between you and refreshment is me. And what I can most profitably do is really draw you into a discussion with Hadley about his remarks, and that's what I mean to do in my own small way to promote that discussion. I would really amplify Hadley's central point before we move to a discussion, and that is this about the personhood, the treatment of personhood, or the lack of attention to the question of personhood in the Dobbs case. And I think it's a bad news story with a little bit of a promise of good news at the end, and I will describe what I mean by that all too briefly, at least tonight. It's true that notwithstanding the fact that there were several very able briefs filed in Dobbs precisely on the personhood for purpose of the 14th Amendment question, and one in particular I thought was especially promising. It was authored by John Finnis and Robbie George. Must have put the baby down long enough to help John put this thing together. But it made an originalist argument for personhood, which in a certain important sense, and maybe I'm not thinking of the right terms, but Robbie and John's brief made an historical argument for personhood and really steered clear of the straight-on moral metaphysical question, who really is a person? When do people really begin? Now, there is no doubt whatsoever that Finnis and Robbie George believe that people begin at conception. That's because that's when our bodies begin. We are our bodies. When my body began, I began. But their argument was that the framers and ratifiers of the 14th Amendment thought that the word person in the 14th Amendment included the unborn. And I thought it was a very persuasive piece, and I dare say even compelling. So this is the brief that was, I guess, mooted, you might say, between Ed Whalen and John Finnis in the pages, or at least online in First Things. It was really quite a, I thought, fruitful conversation online between Ed and John Finnis, in which Ed, for whom I have, unsurpassable respect, said near the end, and I'm paraphrasing from memory, but Ed said, I came into this conversation with Finnis thinking that there really wasn't much evidence, much reason to think on historical originalist grounds that the unborn counted as persons. And Ed said, I moved off that position. And I have to say I'm surprised at the probity of the evidence on that point. And Ed said, I'm not buying it yet, but it's much more of a body of evidence than I suspected. Well, for that reason and others, I think no one thought the Supreme Court was going to declare that the unborn were persons. But I think in light of the composition of the court and the quality of the briefs, et cetera, and also the, I don't know, the plain text, I suppose, of the Constitution, it says all, that is any person. I think it was not unreasonable to expect, as I did, that the question would receive some notice in a footnote. At the highest end, one justice, maybe concurring, would not adopt the position, but endorse the argument, and thereby create the question as a live one after all. The court said nothing about the question and the briefs, at least explicitly. And I wouldn't say the court ignored the whole thing. I think it's a studious silence. They chose to say nothing. Now here I'm going to hypothesize. Now why might they do that? I think one reason would be, perhaps among others, perhaps because of what Brett Kavanaugh required of them to supply the fifth vote. But I do think that it's quite possible that one or more of the justices in the majority had the following view. I'm unable to say anything really critical about the position articulated and defended in the brief, but I'm unwilling to say anything positive. And that's quite possibly what one or more justices thought. So that's disappointing. And the text of Dobbs rolls along, and at least by implication, denies that the unborn are persons for the purpose of the 14th Amendment. Because, and note, I think Kavanaugh uses the term neutrality 13 times. The majority never uses the word. But in the substance of much of what they do say about return to the states, different sides have to make their arguments, contending sides argue it out, the people resolve it. It's implied that people aren't people when they're first conceived. So that's the bad news part. The good news, I think, is at the very end. So you might say the door to personhood is closed, the front door to personhood is closed, but there is a back door. And here I'll simply say that is direct your attention to something in the Dobbs opinion among the last several pages where the court is dealing dialectically with arguments against their position, taking on the argument, the claim that viability is a stable, principled distinction upon which you could rest a differential treatment of the unborn, that people, if not people, begin at viability. At least you could say viability is a point at which abortions can be regulated and even prohibited. But in those 3 pages or so, the court makes what I consider to be a perfectly sound argument for the personhood of the unborn. I mean, what they do there, they start out by saying, well, viability can't really amount to anything of value in this argument because viability is about external circumstances. What's the state of medical technology? Where do you live? Are you near a hospital that's really good as opposed to some place where there are only a couple of doctors, good old country doctors? The court said quite rightly, what makes anybody a person has to be something internal, inherent, and not about any external circumstance, just so. And then the court goes on to say, and in the only space of about 6 paragraphs, well then how, some philosophers and ethicists think that viability matters, or if not viability, some other point, the point at which the fetus has feelings or can make plans or has consciousness or feels pain. But the court quite rightly says, according to any one of those criteria, a lot of people who were born wouldn't count as persons. Then the court actually goes on to say, now here it's in a kind of dialectical mode, refuting arguments and not so much asserting or assembling evidence to bolster a claim that is an assertion of the court. But the court actually says, according to the arguments that are on offer about viability, it would be doubtful whether some people who are born, infants, are actually people. Now that's exactly right too. That's the structure of the argument, that people are people from the beginning. That any argument that tries to pick out some point in time on a continuum of the 9 months, define that point in time identified by some characteristic accruing or cropping up, whether it's a heartbeat or pain or anything else. The problem with those arguments, the court said quite truly, is that they don't apply only to the unborn and would exclude some living people. And that's what makes them unsound. So the money line here, before I invite questions and conversation with Hadley, is this. If you put together what the court says in the last several pages, I think you might actually have the makings of a backdoor to personhood in this respect. Permissive abortion laws necessarily suppose, that the unborn don't count, like you and me and even like infants like Laura Bradley in Robbie's Arms. But those laws lack a rational basis because there's no non-arbitrary way to distinguish the fetus before viability from the fetus after viability, from the infant just born, the newborn, from Laura Bradley, age 1. And that's exactly right. My last comment is, and Hadley laid the groundwork for this, for decades, I suppose, we've heard, although most articulately from Justice Scalia, but from other conservatives, legal conservatives, that the question of personhood cannot be resolved as a legal matter. It's not a legal question. So we won't touch it, Scalia would say, because it's a value question. Well, I think this part of the opinion in Dobbs puts the lie to that claim. The court establishes in Dobbs when people begin. And there's nothing in it that I think should be rightly described as a value judgment. It's a matter of logic, okay, looking at distinctions, logic, and the values that do work in the argument are supplied by commitments of our Constitution. Commitments like, once you're born, you count. And everybody who counts, counts the same. That is to say, we have, each of us in this room, the same right not to be killed or even unjustifiably harmed that everybody else in the room has, no matter how old each of us is, how smart each of us is, whether we have a handicap. So once you count in our constitutional order, you count all the way and you count the same. And I think Dobbs shows us exactly the way to go to make the argument that laws that block that, I hesitate to use the word, that inclusiveness at the point of birth or at viability, those laws lack a rational basis. And I think that's the place that pro-life litigation should focus.